this evening's panel discussion on the right to protest. I'm Katrina Crossley, Chief Executive of the International Law Book Facility, known as the ILBF. I'm very grateful to LexisNexis for hosting the event and to our panelists for joining us this evening. We're honoured to have you here. The ILBF is a charity that ships donated legal textbooks to organisations all over the world. Since we started in 2005, we've shipped over 88,000 books to 280 organisations in 57 countries. Our mission is to share legal knowledge, but we also want to help the careers of the next generation of lawyers, which is why we hold an annual essay competition for law undergraduates studying in the UK. This year's competition was launched at the end of November last year by the Right Honourable the Baroness Carr of Walton-on-the-Hill, the Lady Chief Justice of England and Wales. The competition winner will spend a week on work experience with our competition sponsor, international law firm McDermott, Will and Emery in London. The essay question is, should the right to protest be unfettered? Deadline for entries is the 29th of February at 4 p.m. You can find all the details of the competition and how to enter on the ILBF's website. Insights and inspirations from this evening's discussion, I'm sure, will be invaluable. But the right to protest is a vitally important topic that is relevant to all of us as practitioners and as citizens. And I'm delighted that this evening we have a very diverse audience from academia, the legal profession, organisations and business, as well as law students. I'm very grateful to James Harper, one of the ILBF's patrons and a great supporter of our work, for moderating the panel discussion. By way of introduction, James is General Counsel of Global Nexus Solutions, which is part of LexisNexis. He's also the executive sponsor for the Rule of Law and Corporate Social Responsibility at LexisNexis. I can't think of a better person to moderate this evening's discussions. James, thank you very much, and over to you.
Thanks, Katrina, and good evening, everyone. An interesting introduction in the sense that I could think of a lot of better people to moderate the panel on the basis that I know very little about the law around the right to protest. But in some ways that might help, because my role is to play the role of the audience with our expert panel, and I will introduce our panel in a moment and you'll see just what an expert panel we have, to ask the seemingly silly question when I don't understand something and to help kind of move us through today's session. So I hope I can do that. Let me introduce the panel who are going to be talking to us this evening. First up, we have Kirsty Brimelow, KC from Doughty Street Chambers. Kirsty has an in-depth practitioner expertise in criminal law, also in public law and international human rights law, with particular expertise in homicide, fraud, sexual offences, drugs and torture cases, child rights, vulnerable witness cases, and the law of peaceful protest, most importantly for today. Kirsty is in fact the only KC to have represented protesters in both civil and criminal court of appeal actions, which established legal precedent. Then we have Raj Chadha from Hodge, Jones and Allen, where he is the head of the Criminal Defence, Financial Crime and Regulatory Department. He's one of the country's leading criminal lawyers with expertise in serious and complex crime, public order and financial crime. We have Akiko Hart, who is the Director of Liberty. Akiko was previously the Chief Executive Officer at NSUN, the National Survivor User Network, and previous roles include Director of Mental Health Europe. She has a background in rights-based campaigning and policy work in racial justice, criminal justice and mental health, and has written widely on those issues. And last but very much not least, we have Tyrone Steele, who is Senior Lawyer at Justice. Tyrone works on a range of issues to make the system fairer and more accessible, including the right to protest. He is the author of Justice's landmark report, The State We're In, Addressing Threats and Challenges to the Rule of Law, which came out in September last year, and I'm sure we'll be hearing more about this evening. And he's led Justice's responses to a range of bills, including the Police, Crime and Sentencing and Courts Act 2022 and the Public Order Act 2023. Again, I'm sure we'll hear a little bit more about that as we go through today's session. So that's our panel, a fantastic group of people. Thank you all so much for giving up your time to speak to us this evening. Let me outline exactly how today's work, and then I'm going to step back and let you hear from them. So first up, we're going to hear from Kirsty. Kirsty is going to outline the current and developing position of the law in relation to protest, both from a legislative and a case law perspective. That will include how far we've actually come from a time when we were considered to be in a place where the state should have broad shoulders, that well-known phrase. Tyrone is then going to focus down on the legislative process itself and some of the exemptions that have been included on the prohibitions against protest, especially around journalistic protections, before then turning to talk about the report I mentioned earlier and the wider context of protest as part of the rule of law in the UK. Akiko is going to take us away from the specific law and looking at the socio-political aspects of the right to protest, its history as a part of the British tradition, its role in local society, as well as at a national level, and our need to reframe protest. And finally, Raj is going to bring this background to the courts and legal process, including specifically at some cases that are going through or have recently gone through the courts. How do those cases work? What's debated? What's the experience like for those people in those cases in the court when they're going through it? That should take us up to about the top of the hour, and we will leave about half an hour for audience Q&A. You will see within the Teams function there is an ability for you to ask questions. I'll be making notes as well and trying to ask questions of my own, but if you have questions for any of our panel or for all of the panel, feel free to put them in the Q&A. Those will be moderated, and then we will take as many of those as we can at the end. So that's all the setup that you need to know. I'm going to hand over to our first speaker, which is Kirsty. Kirsty, over to you.
Thank you very much for the introduction. It's always strange just staring at a screen and knowing that there's a whole mass of people out there who I can't see. But I'm hoping to see you a little later with the questions that you're going to ask. Now, I'm going to give you a real whistle-stop tour through the law of protest. And first of all, you start looking at common law. And it's always very important with an old jurisdiction such as England and Wales. And so is the right to protest, is freedom of speech, freedom of expression, is this a common law right? The answer is yes, and that's very firm ground. And quite often when I make speeches to juries, and I'm sure we'll hear from Raj later in a similar vein, quite often we as lawyers will reach right back in legal history to provide some really famous examples of where protest has actually engendered or certainly probably sped up social change, and suffragettes is often used as one example. So yes, there's a common law right to engage in public protest on matters of public concern. And this reflects the fact that public protest is a form of political expression. So sometimes, although we don't have a written constitution, sometimes it's expressed in a way of saying this is that freedom of expression has a status of a constitutional right. And you find that freedom of expression is one of the rights that also gets a special mention at a supranational level. Just sticking with common law, a case that quite often you will find referred to in courts is a case of Redmond Bates and a judgment of Sedley LJ. And he said this, which is, although that case was back in around 2000, it's just as relevant today when you're looking at freedom of expression. And he said free speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, provided it does not tend to provoke violence. And of course, we are talking about peaceful protest. And that is a very important line that you will see is drawn when jurisprudence is looked at as to whether there is any violence or whether it actually is peaceful. I'm moving us on to a little bit more recently, and I hope I can be forgiven for, of course, referring to cases that I've been in, and I'll leave Raj to refer to cases that he's been in, and sometimes they are the same ones. But I'm going to refer to Quadrilla against Lowry. Now, that is a case which was a civil case, and you might remember that there was a period of time in particular where protesters were finding that they weren't so much being restricted by police. In fact, they were being arrested and released when they were protesting, but they were finding that there was injunctions against them by big corporations. And as many of you will know, if you are found to have breached an injunction, then there's much less flexibility on sentence. So gone are the very light sentences that you would get on a criminal offence of a peaceful protest, a sort of sitting down type of protest. But breach of an injunction is effectively contempt of a court order, and that would usually have prison, well, it has prison attached to it. And so therefore you're in the territory of arguing for a suspended prison sentence. And so there was concern that actually the corporations were doing their private policing of protest and really superseding state powers and bringing in their own draconian measures through the use of injunctions. And injunctions also were very wide-ranging injunctions, including against persons unknown. So if there was to be some protest in the future, for example, against fracking sites. And Quadrilla was a company that was carrying out fracking in a part of the country that is very close to my heart because it's where I'm from originally, and it was on Preston New Road up in Lancashire. And fracking was being carried out there. It had been, the license had been refused by the local authority, by Lancashire, because of the strength of public opinion against it, but it had been granted at national level at Westminster. And so it was a very controversial activity. And just to cut a long story short on that, it eventually did stop, I think, after there was a little bit of there was one earth tremor too many, and when it hit the rather or the richer part of Lancashire, moving across to St Helens, I think enough was enough in bringing that to an end. But in the case of Quadrilla, Leggett, Lord Justice Leggett, as he then was, he's now in the Supreme Court, he said this about civil disobedience, and this is always worth considering when you're looking at the core of the importance of civil disobedience. He said, civil disobedience may be defined as a public, non-violent, conscientious act, contrary to law, done with the aim of bringing about a change in the law or policies of the government, or possibly through, though this is controversial, of private organisations. And he referred back to John Rawls, and the theory of justice, which is back to that publication in 1971. And he said this, that where these conditions are met, such acts represent a form of political protest, both in the sense that they are guided by principles of justice or social good, and in the sense that they are addressed to other members of the community or those who hold power within it. So there's a very good, pithy description of civil disobedience and its importance. What about human rights? I can hear everybody asking. We've done common law. Human rights, of course, the European Convention on Human Rights protects the right to freedom of expression, and that is Article 10, which you will hear often referred to, and also Article 11. So Article 11 is the right to assemble, and Article 10 sets out the right that everyone has the right to freedom of expression. This right shall include freedom to hold opinions, to receive and impart information and ideas without interference by public authority. What's very important is this is not an absolute, unfettered, unqualified right. And the right is qualified by subsection 2, which is basically saying that there can be restrictions prescribed by law, and this is the important bit, that are necessary in a democratic society for the prevention of disorder or crime, for the protection of the reputation rights of others. So it's a balancing exercise. And what we're looking at really today is, has that balancing exercise gone too far? But first of all, you might wonder whether the law is developed to mean that direct protest is covered by freedom of expression, or is direct protest something different? Well, again, that has been covered very comprehensively in the case law. And forgive me again, I'm going to refer to another case I was in. It was a case called Roberts. It was also about that fracking at Preston New Road, but this was a criminal Court of Appeal case. And here the protesters had climbed on the lorries which were carrying drilling equipment to the Quadrilla fracking site. And they actually remained on the lorries for between 2 and 3.5 days. And so this was a major carriageway between Preston and Blackpool that was being blocked. And it certainly caused massive disruption and inconvenience to thousands of people, including local residents and businesses. And those defendants were convicted after a trial of public nuisance. And in that appeal, when their sentence was considered and their sentence of imprisonment was quashed and reduced to conditional discharges, they would have got community service, but they'd already spent a number of weeks in prison. But in that case, then Lord Chief Justice Burnett said, there is no doubt that direct action protests fall within the scope of Articles 10 and 11, so they're protected. Now, very briefly, what's changing? Well, rights are definitely being restricted, and you will have seen this. So we've got the Police Crime Sentencing and Courts Act, which came into force in 2022, and this includes a restriction where if the protest is basically unjustifiably noisy, that can be a reason for restriction upon it. There's been an increase in prison sentences, including for damaging of statues. That's been increased now to 10 years. And also the Public Order Act in 2023 includes criminalising for locking on. And this is where protesters fasten themselves to objects in order to inhibit their removal. And we saw this new offence of locking on or suspicion of going equipped to lock on being brought into play during the coronation. And what we did see there was really a bit of a disaster all round with its application. None of those people who were arrested were actually charged. Some of those arrested were in fact those who were avid royalists who then missed the coronation, and others who were part of an NGO, an organisation called Republic, set out that in fact they have been in conversation with the police for a long time about their protest, and that of course they should be entitled to stand there with signs saying that they are for Republic and against the monarchy, and really pointing out that it's only in states such as China where dissent is taken as criminality and people are removed. So that is where we ended up, and I will finish on that demonstrations might be really annoying, might be incredibly irritating, and might even be offensive. However, coming back to that quote that was opened with about the state must have broad shoulders, that comes from a case called Tabernacle. Those of you who are actually studying in this area, go back to that case. It's always very useful in saying really the state has to be the grown up with this, and just go very lightly on the restriction to protest, because it has been shown historically often to be right, and it really is the lifeblood ultimately of a democracy. But I'll stop there. Thank you very much.
Thank you, Kirsty. I had one quick follow-up question of something that struck me in there, which I find fascinating. I find language fascinating. And one of the things I kind of picked out in there is this concept of a protest being unjustifiably noisy. I think that protesters could find lots of reasons to justify why their protest was noisy. And if they're struggling to justify it, then they might need to be a little bit more imaginative. But who decides what's justifiable and unjustifiable? Or is that waiting determination before the courts in a sense of kind of normal legislative interpretation?
Yeah, I don't think it's actually been, I'm not sure there's anybody it's actually been used against anybody, but it comes down to alarm, distress of your bystander. So there's basically an objective and a subjective test, including in it. The unjustifiably noisy is a little bit of a paraphrase on my part, but ultimately it was a real concern, and there was a lot of pushback on having anything within legislation that was about noise of a protest, because that obviously is part of what a protest is. They are noisy, but I'm not aware of it actually being tested yet, that it is such that it would cause alarm and distress.
Interesting. I remember from when the law
yeah.
was passing that was one of the key things that people were debating, that you can't really have a protest without kind of making a bit of noise. So really interesting.
Absolutely. I think the other aspect which is really important with this part of the legislation as it was coming through was that, of course, the police were saying we have sufficient powers, we don't need anything further. They already had sufficient under the Public Order Act, and so you have Section 4, Section 5 Public Order Act, which would deal with something which is going to be such that it's over the usual common sense level of a kind of noisy protest. I mean, you have to apply just some realism to it. Yeah, you can't legislate for everything.
No, absolutely. So, well, but looking at legislation specifically is a perfect segue into Tyrone's section. So Tyrone is going to look, at least initially, at some of those pieces of legislation that have passed recently. Justice, if I remember rightly, Tyrone, were quite involved in some of the construction and writing of the latest legislation, including the rights of journalists to attend protests and not be arrested or interrupted in reporting on protests. And that was something that Justice were quite involved in. So would you like to start there? And then I know you're going to take it then into kind of setting protest within its place within the rule of law.
Brilliant. Thanks so much, James. And it's a pleasure to be here this evening with an excited, a great crowd of people who hopefully, like Kirsty said, we'll be able to see later when we come to Q&As. So I'll just kick off, as James suggested, by going through, I suppose, some of the recent legislation that Justice has been involved in. And I think it's important to take a step back and start from that principle, start from that kind of that recognition of the need, the ability to voice grievances, to stand up for a cause, and to demonstrate one's belief. It's central to human rights. It's central to our human rights culture, and it's something that is, as Kirsty identified, protected by the European Convention on Human Rights as well as the common law. And these principles are important. This ability is important. It enhances the rule of law by allowing for proper public discussion, awareness, and most vitally, state accountability. And so despite that broader context, that statement of principles, we've seen in recent years, certainly since kind of 2021, a real escalation in the legislative attacks against the right to protest that restrict and indeed criminalise many of the forms and the ways in which individuals have sought to protest and assemble and ultimately make their voice heard. And I think an important overarching point about this legislation is the fact that it's been constructed in such a vague manner, so that even peaceful protesters certainly are caught by this, but even those who are passers-by, those who are doing things which we would otherwise consider just ordinary daily activities are potentially or could be caught by the legislation. And that's really one of the main mischiefs, I think, of the two pieces of legislation I'll briefly discuss. It's the fact that you introduce an enormous amount of discretion for the police to clamp down on protests depending on their own subjective perceptions. And as we know, police change, governments change, and there's an inherent danger to allowing for that level of discretion on something so important, particularly with respect to fundamental rights. And I think another historical context and point to note is the fact that we've had in this country a relatively settled regime of legislation and guidance and practice that form the overarching framework of protest law since certainly the Public Order Act of 1986, albeit that's not without its own problems. We can recall the fact that legislation itself was introduced in the context of the miners' strikes, and it was the Thatcher government's response to those incidences. So taking the two pieces of legislation in turn, starting with the Police Crime Sentencing and Courts Act 2022, the PCSE Act, as it's known among those who've had to stare at that bill for countless nights while it was going through. It does two things. Overall, it severely restricts the right to protest. We've established that, and I'll go into a bit more detail as to how. But I think it's important to note as well, when it came forward, it was immediately a very highly controversial piece of legislation. So you had, I think, as Kirsty mentioned, ex-police chiefs and senior advisors, 3 UN special rapporteurs, I think petitions from over 800,000 people, a coalition of 350 civil society organizations, justice and liberty included, expressing their concerns over the human rights implications. So these weren't, unanticipated problems. So what does the PCSE Act do? It allows the police to impose restrictions on public processions, public assemblies, or one-person protests. And notably, as Kirsty said, if the noise that those protests generate cause alarm or distress. So even where it might cause disruption, generating noise, you would think, is normal as the part of exercising the right to protest. Protests tend to be noisy. I'm sure many of us here on the panel or attending here now have attended protests and can attest to that. People who disagree with the cause of a protest might feel alarmed or distressed by the noise, but that has to be tolerated. That has to be kind of accepted as part of the social contract of the protesters and wider society. And so there was a kind of inherent problem with that kind of proposal, that kind of ability to restrict in that way. And I think there's also factors with respect to the fact that individuals can commit offences unwittingly by attending a protest where the individual, and I quote from the statute, knows or ought to have known that a condition has been imposed. So they're the noise conditions, for example, and there's a strict liability test applied there through the PCSE Act. So, for example, members of the public who happen to be in an area on which conditions are imposed, risk being an accidental breach through no fault of their own. And from justice's perspective, this is clearly unacceptable and would represent a severe interference. So as the PCSE Act was going through Parliament, the government, at quite a late stage in the House of Lords, decided actually this isn't severe enough. I think we need to go further. And so at a very late stage in the House of Lords, it was then Priti Patel, who was Home Secretary, decided to add in further clauses by way of amendment. Those further clauses, they included a range of new offences. I think locking on, Kirsty mentioned, was one of them, and a number of others. And those offences, they're now the Public Order Act, but they originally were in the PCSE Act, or they tried to be in the PCSE Act. Fortunately, thanks to efforts of wider civil society, of justice, of liberty, of many, many others, thousands who indeed protested itself over those measures, the House of Lords took a rather muscular approach and decided to reject and vote out most of the clauses that the government had tried to introduce. And due to parliamentary procedure, they couldn't be reintroduced at that stage. They were dead following that vote. Nevertheless, once the PCSE Act passed through Parliament, the government was quick then to introduce a very short bill called the Public Order Bill, now Act, which contained all of those new offences to try and have a second bite at the cherry, not satisfied with the resistance that the Lords had shown. And the Public Order Act further diminishes the right to protest in a number of important ways. It includes new stop and search powers, allowing the police to stop and search individuals without suspicion in certain circumstances. Whereas these powers were broadly previously preserved for violent crime or purportedly violent crime and terrorism offences, these measures could be used to target almost anyone under the Act. And then following that, an officer could seize any object they found if they reasonably suspected it was a prohibited object. And again, this is defined in very, very, very broad terms. So arts and crafts supplies, a first aid kit, or even a camera could conceivably constitute a prohibited object for these purposes. Serious disruption prevention orders are another new tool that the bill introduces, which, once imposed, they can last for up to 2 years and restrict an individual's movement or participation in particular activities. And breaching an SDPO can lead to imprisonment. So these are very serious tools indeed. Locking on, I mentioned previously, and as Kirsty said, this is an incredibly vague offence. It could be committed even if an individual didn't lock on, and even if the objects that they were equipped with could not be used to lock on. So, You know, a bystander who carries a bottle of water to share with a demonstrator who has locked on or might lock on could inadvertently fall foul of this offence. This is because the bottle could, and I quote, constitute an object used in connection with the offence of locking on. You know, you can see how where you have these very, very broadly drafted offences and a high level of police discretion, you're all inherently inviting abuse to those practices, to the use of those powers. So James mentioned press freedom, and I think this was a particular point of controversy during the passage of the Public Order Act. So while the Act was passing through, there was notably a rise of media attention on the arrests of several lawyers who were simply doing their jobs. They were attending and reporting on protests. So there was Peter McDermott, who was an award-winning journalist who was arrested covering a Just Stop Oil protest near an M25 service station in August 2022. There was Richard Felgate and Tom Bowles, who were both also arrested covering similar protests later in November. Both peacefully asserted that they were journalists filming from a public area. They were detained for 13 hours under Section 1 of the Police and Criminal Evidence Act, and then later released without charge. The one that really took the country by storm, though, was a journalist called Charlotte Lynch, who works at LBC. I think she still works at LBC. And she was also arrested covering a Just Stop Oil protest and accused of conspiracy to commit a public nuisance, despite standing well clear of the protest and also showing the police her valid press card. She was handcuffed, she had her devices seized, and she was held in a cell for over 5 hours because it was clear that she was engaged in legitimate work, which should have been clear from the get-go, you might say. She was then released with no further police action. And so as a result of this, you know, I think it was Hertfordshire Police or whichever police force was just outside of the M25, you know, came under a huge amount of criticism. There was supposed to be an internal review, etc., etc. But I think what struck us at Justice, and you know, we ended up collaborating with the National Union of Journalists, was the fact that the ease with which these existing powers could be used, and the level of abuse that could flow from that. And so Justice, working together with a cross-party range of members of the House of Lords, took to draft a new amendment to the bill, which is now Section 17 of the Act, the Journalist Protection Amendment. I think the Home Office, when they did their counter proposal on the clause, gave it a slightly more boring name, but that's effectively what it was from the get-go. And the purpose of this provision, this amendment, was to ensure that journalists, legal observers, academics, and bystanders who monitor or record the police's use of powers in relation to protests should not be arrested. The police should not stop them from undertaking those actions. Again, you'd think that should be the status quo beforehand, but the fact that the police were so willing to use their powers against a whole range of protests, it was clear that statute was needed. So we were although the overall bill, when it passed with some amendments, remained problematic in many respects, we were pleased at least there was one step in the right direction.
And I think, Tyrone, sorry to just jump in.
I think
that's a useful kind of jumping off point. Just with a minute or so left to look at this within the wider context. So trying to frame the legislative progress or limits to it within the context of the rule of law. And that's part of what Justice's report was looking at, if I'm right.
Absolutely. Well, so thanks for that intervention, James. So protest is a fundamental part of the rule of law. It's a crucial human right. It allows for state accountability. It allows for, you know, the kind of the ability to voice grievances, and it's something that is being repeatedly and severely restricted. And so it was an important example case study within the report that we assessed holistically the state of the rule of law in the UK back last September. And it's something that we're kind of watching very, very carefully. You know, and I think it's important to, I suppose, with the 30 seconds I have left, to situate ourselves and the progression of laws in this country within an international context. You know, you can both look at organisations like Civicus, who do kind of international comparisons of how civic freedom rankings operate, and the UK government was, or the state of the UK at the moment, was described as increasingly authoritarian, in the words of Civicus, and putting us on track to join countries like South Africa, Poland, and Hungary with respect to those civic freedom rankings. To kind of end on a nice judicial rule of law quote, I'll turn to every law student's favourite, Lord Denning, who put it most cogently when he noted that protest is, and I see Kirsty smiling, she probably is very familiar with this quote, and it's often the only means by which grievances can be brought to the knowledge of those in authority, at any rate with such impact as to gain a remedy. Our history is full of warnings against suppressions of these rights. And so I hope that through today's panel event today, we kind of echo that warning again from Lord Denning.
Fantastic. Thank you, Tyrone. And I think that does lead us really nicely into looking at the history of protest and the place where it sits. So Tyrone's quote there from Denning, but also Kirsty's quote or comment earlier from Leggett, who defined civil disobedience as being a form of political protest. So framing that and bringing that, kind of almost taking the Denning point of bringing it to the attention of the authorities when they might not know of it, looks at how protest works on a local level as well as on a national level. So not just Stop Oil, but what happens if your local library is shut and the protest that can happen there. And so that's where we're going to turn to Akiko from Liberty, and you're going to take us through a little bit more of that history and the socio-political aspects of it.
Thank you so much, James, and it's lovely to be here with you today. So looking at your essay title, in my view, the right to protest is not unfettered, and I would argue nor has it ever been, whether you look at it under common law or more recent human rights legislation. I think there is a window of political tolerance for protest or civil disobedience, and that window shifts. And I would argue that the legislation follows that. So at the moment, our right to protest, as we've heard from Kirsty and Tyrone, our right to protest is under threat. Is it unprecedented? I might use that word as a campaigner. I'm not sure it stands up historically. I think we are correct in being gravely concerned about where we are at the moment in relation to our right to protest. And I can think of three ways in which that manifests itself. I think the first one is through the recent pieces of legislation, and we've heard, normally I would go into a little bit more detail about that, but obviously Tyrone has just talked us through this in a lot of detail. So the PCSC Act and the Public Order Act. I think we're also seeing it through sentencing. So Kirsty has touched on this, but we're seeing much, much harsher sentencing when it comes to protests. So for example, in July last year, the sentences of the two protesters who scaled the Dartford crossing, they were upheld at the Court of Appeal. It was quite a complex judgment, but they were essentially judged to be severe but not excessive. And those sentences were 3 years and 2 years and 7 months. So the harshest sentences for non-violent protest in modern times. So we're seeing it through legislation, we're seeing it through sentencing. I think we're also seeing it through process. So as an example, Liberty is currently taking the Home Secretary to court over new powers which the then Home Secretary Suella Braverman unlawfully brought in after the Public Order Act. So this was in relation to the definition of serious disruption, attempting to change that to more than minor. So essentially this change was debated in Parliament, was rejected by Parliament, and then after the Act was passed, Braverman brought it in through a statutory instrument, so through secondary legislation. And so we are taking the Home Secretary to court for this. And what's very interesting about this is that it's not so much protest scholars and lawyers who are up in arms about this, but constitutional legal experts who are. So I think there's something about the way these legislative changes are happening, the process, the urgency. There's something around that which I think is deeply, deeply concerning. So if we kind of like zoom out a little bit, why are we where we are at the moment? And I don't have a clear answer, but I can kind of throw a few ideas at you. I think some of it is political expediency. So some of it is clearly around a reaction to the environmental activists who, and I think that cause has been so what we're seeing is those protests being weaponized as disruptive and divisive. And it's really interesting, isn't it? Because I think both Kirsty and Tyrone have touched on this. Protest is meant to be disruptive. It is not disruptive. It probably isn't working. So the fact that it's disruptive is isn't in and of itself. It should not be an issue. Are they divisive? Actually, I think if you look at the polling around Just Stop Oil, etc., it's far more complex in that it really depends on who you're asking and the kind of big generational divides. But certainly it's been perceived as a wedge issue. And I think, you know, it's been done so very successfully in terms of like turning protest into, you know, a binary issue. So I think there's that. Some people would argue that this is a government that doesn't tolerate criticism very well. I don't know about that. I think it certainly gets a lot of criticism at the moment. I think for me, it raises deeper questions around the state of democracy at the moment and voice, in that our voices can't just be heard at the ballot box every 5 years. That's not how this contract works, not least because not everyone in the country can vote, but beyond that. And protest, I think, is an enactment of that and a reminder of that. And I think it's a reminder that's not sitting very comfortably with people at the moment. I think there's also something in there at the moment that relates to quite a particular modern challenge around pace. And I think there's something about the pace of change, the pace of events, the pace of the news cycle, which I think parliamentarians are really, really struggling to keep up with. And I think that tension is creating new troubles. So, you know, politicians are often accused of being very short-term thinkers in terms of like just thinking about, you know, that their 5-year term. But actually at the moment, what we're seeing is extreme short-term thinking in terms of days, weeks, sometimes hours, and reacting in relation to that. We are seeing legislation that is beyond rush. Whatever your views are on the post office scandal and the subsequent legislation, the pace of that is completely mind-boggling, and you know, and you know, should be raising serious concerns. And I think there is something about the immediacy of protest, and then how those protests are then, you know, shared online and shared on the news, which I think is throwing a lot of decision makers. And I think that is pointing to a kind of political inability to deal with protest. So where do we go from here? So this is coming back to what you were talking about, James, at the beginning. I think it's a real opportunity for us to reframe how we think about and how we talk about protest. At the moment, whenever we talk about protest, we tend to point to Just Stop Oil or the Palestine Solidarity Marches, so these big national or kind of like international causes or marches. But protest is far more than that. So at Liberty, we're a membership organisation. We reached out to our members last year, and we said, tell us about your stories of protest. And people wrote in with the most lovely stories and pictures of protesting about their local library being closed or trees being felled in the local forest. You know, protest is about community, it is about individuals, it is very localized as well as very national. And I think kind of bringing the humanity into it, I think just kind of changes how we might view it. I've seen a lot about protest being fundamentally anti-British, which I think is a really, really dangerous line of argument, but is also fundamentally ahistorical. So Kirsty has already talked about the suffragettes, but it's also the CND marches. There's the big anti-war march 20 years ago, Pride, Peterloo, the general strikes. I think if we take a long view of protest, a kind of like zooming out view, we get away from the Just Stop Oil, they're disrupting my morning commute view of it. And I think that kind of helps us reestablish a sense of balance. I think we need to move away, and this is one of my mantras about everything, from a binary view of protest, including in your essay question. For me, it's not about protest being fettered or unfettered. I think it's a conversation about our level of comfort with protest, and more specifically, if we can extend the discomfort we feel for it as far as we can. And I think it's that space of discomfort where we're going to be able to find some kind of answers to this. And finally, I think it's an invitation. So rather than seeing protest as a source or a manifestation of disorder, to see protest almost as a canary in the coal mine and an attempt to re-establish order, because actually something isn't quite right in our democratic processes at the moment. And I think the protests that we are seeing are almost an invitation for us to recalibrate how our voices are being used and heard within our democracy.
Fantastic. Thank you, Akiko. The thing that struck me in there was a point that you started to build out around the state and nature of our politics at the moment. And the thought that struck me is that the rise of populism itself as a more present form of politics at the moment, and the real polarization of our politics, really flies in the face of protest, because it doesn't accept the fact that someone else might be right and you might be wrong. It insists on the fact that you are right and anyone who disagrees with you is the enemy, rather than just someone else with a perspective. So I wonder if also, like, historically, this is not necessarily a question anyone has to answer, but it's an interesting thought for those writing essays. I wonder if there is a historical trend that where populist and polarized political systems have developed, that protests then become much more kind of subjugated and pushed down within society. For those that experience that, however, and the changing law, the uncertainty in some of the law that is yet to be tested before the courts, that becomes quite challenging, not knowing what that experience is going to be like. But fortunately, our final speaker has stood there alongside Kirsty and many other people as well, but has walked their clients through that room and can tell us exactly what it's like to go through those cases. So Raj, with your time, can you walk us through that experience of what it's like to be in court right now?
Yes, I'm going to talk about a few different cases, as many as I can in the 10 minutes, but just picking up on that theme about protest and why now. Protest is not unfettered. There are limits to what can be done or what can be said or how protest is done. But the nature of protest itself has changed in the last 10 years through social media, through the campaigns. Many, for example, Just Stop Oil, who think that there's an existential crisis, and hence the nature of their protest is going to be different. And to some extent, it's whilst politicians, I think, right, do respond very quickly to the nature of disruption, what they fail to do is to respond to the campaigns themselves. And that's an interesting dilemma that protest puts us in. And I'm going to pick up on that, for example, by the first case, which is that of Nora Ziegler, who was a Quaker who wanted to protest about an arms fair that happens in East London every 2 years, the largest arms fair in Europe, in which arms traders, governments, foreign governments come together, promote weapons for the benefit of the British arms industry. That fair has been found for 5 occasions in a row by Amnesty International to be promoting unlawful weapons, cluster bombs, torture equipment, material that should not have been promoted in the UK. And despite that, the British government continues to license it. The people of Newham, where it's based, don't want it. The Mayor of London has said it shouldn't take place. And needless to say, it attracts mass demonstrations each time it occurs. And Nora Ziegler was one of them. And she lay down in front of a truck that was trying to get into the Excel Centre and locked on to another protester and prevented that truck from entering. And she was arrested for obstructing the highway and acquitted, because the judge in effect said, well, a road is not just for passing and repassing, it is there for protest as well. And the case went all the way to the Supreme Court. This is a pretty minor case in the Magistrates Court, and went all the way to the Supreme Court. And the Supreme Court did say, well, actually, yes, the right to protest is also a valuable right, as well as the right to go on with your ordinary everyday business. And we have to consider under human rights legislation whether it was proportionate to convict her, bearing in mind her right to free speech. And so the defence of proportionality became embedded in UK law only a couple of years ago, really, in relation to protest cases. What's interesting, obviously, is that Nora wouldn't have that ability now because she would be convicted of an offence of locking on. She'd be convicted of an offence of interfering with national infrastructure. And the government responded to that amazing Supreme Court decision by the legislation that you've heard about. Second case is not so much a case, but the campaign, the Extinction Rebellion campaigns of 2019, where hundreds, thousands of people took to the streets in London and took over 4 bridges in London, Waterloo Bridge, London Bridge, and 2 other bridges that I can't remember, and basically kept protesting for 2 weeks and shut those bridges down. Now, it was highly disruptive. The police were heavily criticised for why they didn't respond earlier. But what was amazing was the criminal justice response, and I acted for many of those. Upwards of 1,000 people were arrested, brought to a magistrate's court, and convicted of really minor public order offences. And it was something just to sit back, and it brings home what protest is about in a way. Sit at the back of court, many of them representing themselves, wide range of people from grandmothers to young teenagers, saying, well, I did this because I genuinely believe about the nature of the climate crisis, and I want to bring that to the government's attention. And from that, the one stage that they did get was Parliament declared a climate emergency. And how that has developed in relation to greater disruptive protests by other environmental protesters, but I think we shouldn't forget how it started. But what the criminal justice reaction was to automatically protest, which it shouldn't do. I'm going to speed through a couple of others very quick cases, which was one that Kirsty was involved in, which is Stansted 15. 15 people surround a plane in a remote sort of parking area of Stansted Airport that was going to deport a number of people to West Africa. The 15 people surrounded the plane to prevent that plane from taking off. I've done dozens of airport cases prior to Stansted 15. Normally you're charged with a really minor public order offence called aggravated trespass, and that is indeed what they were initially charged with. 3 months later, the charge changes to a terrorism-related offence. A terrorism-related offence. So you go from minor public order to an offence for which you could get life imprisonment. And those individuals had to go through that, and they were convicted, and it was only at the Court of Appeal that it was overturned. But that's the danger of the use of discretion to clamp down on protest. It really highlights if the state gets too much power, too much discretion, they tend to go for the law enforcement option. The other case, the next case was Colston 4. Many of you will be aware of that. In that Edward Colston was a slave trader from the 17th century. There was a statue that was erected in his name in Bristol. The most offensive part wasn't even the statue, but was the plaque underneath the statue, which says, "For the noblest and wisest son of Bristol." And that caused huge offence to not just ethnic minority members in Bristol, but everybody. Lots of campaigns for it to be removed. The local council didn't listen. It was toppled during the Black Lives Matter protest. And brilliantly, they all got acquitted in a Crown Court, because that essence of a British system of a jury determining what's right and what's wrong could see what the greater good was in that case, and they got acquitted. But both in Stansted 15 and Colston 4, those individuals risked prison. And the level of stress that they were under as individuals, I think we shouldn't really forget. And it's something that when we as lawyers or academics talk about the right to free speech, it shouldn't be a theoretical right. It's what some people practice on a day-to-day basis. The other case then I'm going to briefly refer to is the Insulate Britain campaign. where people sought to block the M25 a couple of years ago. And what was interesting about those cases is that when they came to court, judge ruled out all of the defences, and then said, because I've ruled out your right to free speech defence, you're not allowed to mention the climate crisis. You're not allowed to say the words the climate crisis, and you are not allowed to compare yourselves to civil rights protesters of years gone by. So don't compare yourselves to the US civil rights movement, and don't say anything about the climate crisis, because the jury shouldn't be told about that. It's not a factor in your case. Some individuals ignored that and were sent to prison for contempt of court for mentioning the words climate crisis in a British court. That is and it's all quite logical in a way, but unless you step back and think, where is that logic going to get us? It's very dangerous to get to the place that we ended up. And those cases are now either being appealed or they're being moved, and we're refighting them. And the final case is actually one that came out yesterday, because it goes back to Kirsty's quote from Lord Sedley about speech can be offensive but can still be protected. And that was the case of Thomas Casserly. Mr. Casserly was an individual who was campaigning against his local council about the upkeep of local cemeteries. And Mr. Casserly sent a very, very rude email to a local councillor. And many would find it offensive, actually, because it was to a disabled local councillor, and he questioned whether or not that local councillor could do their job because of their disability. But he was prosecuted under the criminal law under the Malicious Communications Act. And the judge and the prosecution throughout said, Article 10, your right to free speech, doesn't apply in this case because you're in a criminal court in effect, and the criminal process will take care of it. And they were wrong, and the Court of Appeal said that they were wrong. Of course, the jury has to be properly directed as to what Article 10 means, about the value that we attach to Article 10, and ensure it's only the most serious of cases that will attract criminal liability. And so in an array of bad cases that we've had recently in the higher courts, that's the first win that we've had for a while. Because although the right to free speech is not absolute, it is under severe attack at the minute. Tyrone's quoted from the Civitas report, but there's also the UN Special Rapporteur on Climate Defenders, who issued a statement 2 days ago after a visit to the UK, indicating his concern for the clampdown on climate protesters. I think it is unprecedented. I have been doing this job for about 15 years for free speech. I, until 3 years ago, never had to visit a client in prison, ever. I could say to clients, don't worry about it, we will fight your case in court, and you'll get a conditional discharge, one of the lowest penalties. But no, I can't say that. I have to say, you might well go to prison as a result of this. And that is an unprecedented, and it's not going to deter the determined activist, but what it might deter is the occasional protester. And that's the danger of where we're at. I think most people have finished with a quote of a famous lawyer. I'm going to buck the trend and finish with my own quote, which I gave once the noise provisions had been released. And it is this, and it's that, you know, if they had been enforced in 1963 in the United States, Martin Luther King would be whispering in the suburbs of Washington, not dreaming in front of the Lincoln Memorial. And I think that is absolutely right, and that is the danger of where we are and where we're going.
Fantastic. For those that are writing their essays, you'll be glad that this session is recorded, so you can go back and write down that quote from a famous lawyer. So I'm going to rebut the point that it wasn't from a famous lawyer, Raj. Even if that was your own quote, that's perfectly fine. But it's absolutely right, and it's a fascinating perspective to move into our Q&A section. So if you go into the Teams feature, you will find the Q&A section. If you have a question that you would like us to put to the panel from something that we've already talked about this evening, or something else that's on your mind, please feel free to put it in there. I've got a couple of questions that I'm going to pose initially to get us going. And one of them that was striking me when you were talking just then, Raj, was about the Insulate Britain protest on the M25, was how we talk here very philosophically and our very soul about the importance of the rule of law, the importance of certain rights within our society. But then protest can impact us in many ways. So how do the panel feel, and how do they process in their own minds those times when protests directly impact them? Let me give you a for instance. You're on the way to the airport to catch a flight, either on holiday or on a business trip, and Insulate Britain have blocked the M25, and you can see in your head that absolutely they should have a right to protest, but I'm trying to get to the airport, so I don't really care about your right to protest right now. I want to get to the airport. Or you're driving to hospital with your partner who's hurt themselves or is pregnant, or with your child who is unwell or something like that, and Just Stop Oil have blocked the road and you can't get round them, and you see people getting out their cars and dragging them off to the side of the road. How does one process and balance those feelings with a fundamental belief in the right to protest? I'll let the first person on the panel take a punt at that, and then I'll start picking.
I'll have a first go. I think it is really difficult, because there are various expletives that will come out of your because I don't like to be disrupted. Nobody likes to be disrupted, and that's why protest isn't unfettered, and there has to be a balance. The issue about how the criminal justice system has responded, though, is whether they've got that balance right in terms of what the level of punishment is against those individuals, and whether they've had the right to tell their story. But there's a more fundamental issue about the government's response, which is how I started my talk, which is, well, some of these campaigns need to be addressed. Had they listened to the XR campaigns in 2019, we may not have had the Insulate Britain campaign. And these are fundamental issues that threaten our very existence. And it's the first campaign that isn't based on civil rights, mass disobedience on civil rights, or one single issue in a way. It's based, they would say, on the very survival of humanity. And that's why they've developed into a completely different sphere. So I would question, if I'd been in government, I would have said, why are up to 2,000 people protesting in central London, and what can we do that might address those concerns rather than a criminal justice response?
Akiko, go.
Thanks. So yeah, I mean, I am very much in agreement with that in terms of, that kind of personal reaction. It can be profoundly irritating. And you've got to kind of, well, you don't have to do anything, and that sits alongside, all my other beliefs around the right for people to protest. I think for me, one of the kind of like challenges around this conversation is that I'm often in a room with people who broadly agree with me around this, unless I'm doing media. And there is perhaps, and I completely agree with you, Raj, that there is a sense of, well, what if young people are taking to the streets and talking about climate, the climate emergency, why aren't we tackling, the substantive issue? And all of that is, correct. But to your point, James, earlier on about kind of populist protests, by which I think you mean right-wing protests, I think we would find it much more difficult to have this conversation as a panel if what we were witnessing in the UK at the moment were large-scale, very right-wing protests. And I think we would still stand by people's right to protest, but I think the conversation would be quite different, and I think it's important for us to engage with that at some level, because when we see the right-wing protests happening, in EU member states at the moment, they certainly they really challenge my sense of the right to protest and what that looks like in a kind of democratic space, and I find that quite a useful challenge.
I'm happy to also jump in and give a few thoughts on that. I think also in agreement with Raj, both at the kind of personal level, of course, we can't help but be annoyed if your train is delayed. I mean, I live in London and get frustrated when there's more than a 2 or 3 minute time to wait per tube, which I know is a very privileged position to be in. So no, I understand that kind of short-tempered element. But taking a step back, as Raj does, and I think it was quite profound when he said the fact that he's now having to speak to his clients and say you might go to prison and actually visit prisons, whereas a couple of years ago that wasn't the case. I think this does tie into that wider conversation, to the wider point I was making at the end of my contribution around the degradation of the rule of law in the United Kingdom. We have a situation where from the kind of in the legislative process, things aren't working, scrutiny isn't being given properly, equalities are declining. You're seeing severe challenges in access to justice. All of these elements together result in a kind of, I suppose, an unfortunate scenario where if you do not feel your voice is being heard through the regular channels and means which are there to facilitate that, then of course you're going to see a rise in protest. And the reaction of the government seems to have been less around, well, let's adopt some evidence-based policy making to grapple with those issues, and more, let's play whack-a-mole in terms of criminalising various different aspects in this kind of hodgepodge way. I mean, it was kind of ludicrous to see the PCSE Act go through, and even as I mentioned before, you hadn't even completed that legislative process before the government was whacking in even more offences. And there was talk, I think, back around the Truss government, if you can remember that, of adding even more offences to the statute book. And as you do that, you're going to end up restricting severely and chilling, peaceful ways of protesting, and I think diverting it into more what the government would deem extreme manifestations. And so I think that's one of the challenges.
If I could just add to that, I think it's a really interesting point, actually, James, when you do see, as we've seen, when members of the public, getting out of their cars and were moving on that particular protest, moving people to one side. I mean, what I would say in relation to that, and I remember another similar one with an Extinction Rebellion, and there was a couple of protesters on top of a tube at Canning Town tube station, and again it was just misconceived. You could actually tell that those two protesters were not from London, because that was just not the station to choose. I'm surprised they managed to get away from there without any injuries, actually, but that was where the commuters managed to pull them down and sorted them out. And I just don't think, as I sort of said earlier, you can actually legislate for everything. And so when you're looking at, should we have had more restrictions here to prevent this happening? The answer is likely to be no. However, I think it probably puts a little bit of sort of social onus back on the protesters to consider, well, actually our campaign is not going very well here, because we are causing perhaps, or potentially causing, more irritation. We've got it wrong. And I certainly know with that Extinction Rebellion one, there was a lot of communication to those particular protesters from others in Extinction Rebellion saying, don't do this. This is going to backfire very badly. And I think Extinction Rebellion, we saw how they started to change their tactics as well. So protesters can also reset and feel that temperature of society. And frankly, as long as it's done in a pretty proportionate manner, you've always had a situation where members of the public are perfectly, they do have some agency to actually intervene and say, look, get out of my way. I've got an absolute emergency here. You don't have to do everything through a police officer. So in relation to that, I would say it's more something for the protesters to consider. And we certainly saw that with Insulate Britain, because in some ways, and this is where there is a difficult balance with the new legislation, is that in some ways, the further away the protest is from the actual site of the thing that you're protesting against, the more difficult it is for people to actually make that link and understand. And so, ironically, we have new legislation in which is causing a new set of offences in relation to protesting against protesting outside the actual infrastructure. But in fact, that's easy for people to understand. If people are outside the factory, they're outside the power station, they're outside the place where the protest is focused, the arms fair or whatever, then I think people accept that more. It's more of a difficulty of how is sitting on the motorway actually going to deal with the issue of heating in houses, and so I think it's that disconnect that people also find as well, which actually is addressed sometimes in some of the case law when the courts are actually looking at the kind of purpose of the protest itself. So I think there's quite a few interesting points around the use of protest and how it evolves and kind of flows in different ways in relation to its effectiveness. But the state should always be careful in adding an additional layer of restrictions, because it sees members of civil society stepping in and saying, right, I'm going to sort this, as long as it's not violent.
Yeah, well, the state's action, I think it kind of came out in Raj's points, but kind of builds on what you were saying, Kirsty. The question being, has the actions of the state made those more kind of extreme protests worse, at the same time as making minor protests rarer? So protesters are saying, I'm going to have to do something material and big, because if I'm going to be, I can't remember what the expression is, if I'm going to be done for a cat, I might as well be done for a lion, or whatever the expression is. I'm going to go down one way, so I might as well make it big. And then the people at the other end of the scale that are protesting at a local level, I'll go, well, actually, do you know what? I'd like to go and protest about my local library being closed, but I'm kind of worried about the implications of that. And it doesn't feel as world-ending as Insulate Britain or Just Stop Oil. Do we think that that's a direct correlation between the state's actions and how protesters are feeling?
I mean, I come in very briefly. So I'm not sure that the average person has a hugely in-depth understanding of the changes in legislation around this. I just don't think it's kind of cut through in any way, I would say. So I don't think that would stop the vast majority of people, protesting in terms of their local library, etc. I don't really see that. I think where we've seen it a little bit at Liberty is around some of the big marches, for example, where you've got a mix of people who are kind of planning to attend, but don't realise that the restrictions have changed, that legislation has changed, and therefore come to us for advice around it. And people who and instances where we are seeing the chilling effect, essentially. But I think that's on more high profile events rather than the kind of smaller scale ones at the moment, I would say, and more for people who are kind of slightly in that world already. My gut feeling is that most people don't know that the law has changed around protest. I could be wrong.
I guess maybe one way it is noted is probably in the, just to briefly add, when you see images of protests now on the television or the news, it's a much more, or at least it seems to be in recent years, visually much more securitized. So you will see protests and you will see police, and they're kind of, those two things are very much entwined, which makes it seem like a riskier prospect. But that's, I suppose, a bit of speculation.
You're on mute, Raj. Very, very 2020 of you.
Thank you. if only we could mute free speech like that, the government. I think it's not so much the government reaction. I sort of agree with that. Well, I think it is the culture of trying to be heard, and in this world where newspapers are still dominated by a small number of owners, still have a particular political persuasion. There are many people that feel, Tyrone mentioned earlier, that they don't have a way into our democracy. And if an initial protest didn't work and didn't get their voice heard, then perhaps we need to do something else. I think that's the debate that is in amongst protest groups, and that relates. There's a very famous speech by Robert Kennedy in South Africa where he talks. You can talk about the right to free speech, but it has to be allied with the power to be heard, because otherwise it doesn't mean anything.
Yeah, I mean, I think I'd add to that. I mean, I was really actually struck by what Akiko said about a person's voice as well. And it's not, I think, because we're in such different times with 24-hour media. We've been 24-hour media for a long time now, but when we look back at the sort of the original jurisprudence around freedom of expression and protest, it was a very different world. Now somebody posts something on, I'm still going to call it Twitter, X, right? But somebody posts it and they want a response to it, and they want a response quickly. And now that's not going to happen. And so therefore it can then become something where they'll get others, and then before anything else happens, it then becomes something which is akin to a protest, and it can be all sorts of different types of protests. So I think the way we communicate to each other and our expectation of being heard by those in power has changed the dynamic so much that the state is, perhaps what we're seeing much more is the state frightened of people's voice, because they're looking at, actually, okay, but you only do this going up to the election. We really don't want to have to deal with this beforehand. And we also, I really agree on process as well, on what we've seen is a massive increase in secondary legislation. And so that is getting in really interference with fundamental rights, but done without it having to go through the parliamentary process and the scrutiny and the debate. And I mean, this has been a sort of drip, drip, drip. And we're seeing it also in the court system as well. So the process needs to be really turned back to have prime legislation. If you get the voices coming through Parliament again, then you might not see it out on the streets in the same way.
Mm-hmm.
I think. Sorry, James.
No, go ahead.
I was just going to briefly add, I think that's one of the things that made us so concerned with respect to the escalation in the arrests of journalists as well, and then ultimately not charging them, because it, obviously it's very unpleasantly put in a police cell for 5 hours or 10 hours or however long. That's unacceptable, of course. But it's the fact that you have that person taken away from the protest site and unable to report on it and unable to disseminate that more broadly for kind of the larger, wider public awareness. And that doesn't as well exist in a vacuum. The UK has quite a middling press freedom kind of standard reputation. I think we're 24th in the world, categorized as yellow, I see from the report, which is satisfactory and generally not good. So I think that kind of point around public access and the ability to kind of scrutinize, I think, also probably gives a bit more color as to why the police, I guess, were potentially encouraged to act in the way they were.
So I want to try and combine a couple of questions that we've had from our audience into one, because I think there's an interlink between the two. So the first one is that it was said that protests can reveal certain discrepancies in the current political system. Where does the balance lie between continuing to push for political change and the increasing limitations that are being placed on doing so? So that's one of our questions. And here is a piece of context which kind of takes that in a specific direction, which if we can frame our answers around this as well. It says a little bit longer, but I'll read it quickly. We had Baroness Casey's report in 23 showing the Met Police as institutionally racist, misogynistic and homophobic. We've had Suella Braverman saying that flying a Palestinian flag may not be legitimate. And we have members of the Met Police wearing thin blue line badges on their uniforms, which the questioner calls a symbol of far-right groups. How concerned are we that marginalised groups will be the most affected by new policing powers? And are we seeing evidence of that in our work? So that balance between pushing for political change and the increasing limitations and the impact that that has on marginalised groups.
I mean, I think it does have a profound impact on marginalised groups. I think inherently they are first to face the brunt, both in particular with respect to this legislation and these types of powers, but also then more generally when you ask the question, well, who is it that is exercising those powers on the front line? Of course, as you say, it's principally the police, but other parts of the criminal justice system as well, where disproportionalities and discrimination pervade. It's one of the reasons as well why, and I think everyone here has spoken to the fact that, inherent to wider discretion is a heightened risk of the abuse of power, and the fact that we've seen that through that legislation, this broad amount of discretion, combined with the fact that we're awarding this new discretion, these new powers to a lot of discredited police forces who've come under a amount of scrutiny. It's it's deeply concerning.
I think it's the most contested, and this may be an element of the cultural wars, I don't know, but it's the most contested time in the criminal justice system that I've experienced. It used to be, we were all professional, prosecution, defence, police, everyone has their role to play, everyone understood what their role is. It feels a lot more contested now. It feels like prosecutions are required and results are required and officers want that, and then you have a legislative framework that backs that up, and to some extent maybe from the defence side as well, and I think that's a really dangerous route for the criminal justice system, dangerous time for the criminal justice system to be in, and I think that's what's behind the Casey report as well. So it just backs up what's being said about discretion, about trying to ensure that power is exercised appropriately. And that the state acts as officers of the court, not as a party to try and get one side or the other. And I think what I find profoundly disturbing was when there was briefings to the press about the new legislation, it was specifically said that this was to get Extinction Rebellion and Black Lives Matter protesters. And I think that's a bit worrying.
Akiko, did you want to come in on that?
Yeah, I can come in briefly. So yeah, I think you're absolutely right to be worried about how these changes would disproportionately affect marginalised people in communities. That's what we've seen historically, and that's what we're continuing to see. I was going to, sorry, that's why I was grappling for my phone. I was going to point you to a blog which I found quite extraordinary, and I think it's on the Police Foundation website, which is the UK's policing think tank. So it's policing people writing it, and it was during those torrid last few days of Suella Braverman's days in the Home Office, when there was to and fro between the Met Police and the Home Secretary around protest. And there's a quite extraordinary piece there that you will have to, we can perhaps share in the chat. Explaining or we're arguing that the Home Secretary has overreached in this instance in terms of policing powers, and it was extraordinary to see this written by the police at that time, and in terms of the flag. It was also the Met Police that issued guidance saying, it's not about the flag, I'm sorry, the chant from the river to the sea. It was the Met Police that issued guidance saying that the chant on its own did not constitute a criminal offence, which was, in opposition to what the Home Secretary had said. So I think we're living in quite extraordinary times where it's not liberty or justice as human rights organisations pointing some of these things out, but where actually you have institutions like the police doing so as well.
Yeah, I mean, Akiko, again, I was going to come on to that actually with the demonstrations, and I think of a positive note, in fact, the demonstrations, the Gaza demonstrations, have been policed in a way where I think we should give credit to the police for how they have handled those demonstrations. And I've seen some of them. I went out of curiosity to observe some of the earlier ones when there was a lot of stuff on social media against them, and I thought it was very proportionate. I think what it would be nice to do is to go back. So in terms of the question, political change, the absolute starting point is there's your right to protest, and then you look at what restrictions are actually being imposed on the protest, and are they proportionate or not? And you've got proportionality that you can consider in this common law test, and also as Raj has said, Ziegler's a good one on proportionality. But I think what we used to see in practice, particularly with Extinction Rebellion, was the police would adopt this 5-stage procedure, in that if they were going to interfere with a protester, they would really have to give them an opportunity, first of all, to move away. If it was a sit-in and it was felt, okay, now it's disproportionate, the balance is such that we need to allow people to come through, they would give them the opportunity to move away, and that arrest was very much drilled into the police to be an absolute last resort. And similarly, again, across the European case law, criminal sanction is a last resort on protest. So that is still there. And I think it would be quite nice just to go back and remind our police of that 5-stage procedure, because it seemed to work incredibly well with protesters who were, okay, you're on your last chance now. This is your option. You either move now or you will be arrested. And a lot of them went, okay, I'll take the decision to move, please. And in fact, I had some of those cases where, we had some lovely old people who were like, can I move please now? And then the police arrested them anyway. So we had the challenge in that way. But it was just a very easy way to apply proportionality when they were interfering. And it's quite a good one to go back to. But I was encouraged by recent policing, which was not whipped up by the political soundbites, some of which were absolutely appalling.
I think proportionality is a fantastic place to leave it as a guiding principle for where we would like to see this go, albeit that things may not be looking particularly bright, but it should have given those listening to this evening session plenty of food for thought for writing their essays, those that are taking part in the essay competition. So hopefully you will be able to use that and some of the other thoughts that our panel has shared with us this evening. I'm going to take us and wrap us up now, given that we are just coming up to past. So I would like to say thank you, first of all, to our incredible panel, to Kirsty, to Akiko, to Raj, to Tyrone. Thank you so much for sharing your time and your expertise, both this evening and in preparation for this session. For anyone who's listening who's done a webinar before, it's not just a case of turning up. There's lots of things to think about and prepare in advance. So we're incredibly grateful for the time that you've given. I want to say a quick thank you as well to my colleagues Sasha and Martina, who have been working in the background, both from LexisNexis, preparing the tech, taking in all the invites, making sure everyone was here, and getting everything set up, as well as promoting the event tonight. So thank you to both of you, and to Katrina as well from the ILBF. I cannot commend the ILBF more to those who have not come across them before. It is a fantastic organisation that takes a very simple premise of taking good quality second-hand legal texts, and instead of seeing them go to waste, repurposes them and ensures that more people can access the law, which is a fundamental tenet of the rule of law. And it's been doing that for a number of years, reaching any number of countries around the world with tens, if not hundreds of thousands of legal texts. So if you've not spent a lot of time listening or hearing about the ILBF, I commend them to you. Go and have a look at the website and follow what they do. Finally, a final thank you to those who have attended. Thank you for spending your early evening with us. We're very grateful, and we hope to see you on another one of these sessions again soon.
Thank you.
Thanks, everybody.
Thank you very much. Take care.